Good evening to everybody. Welcome to the today class of the to the students advanced private international law, and welcome to my class. And we are dealing with the conflicts in family law, that is the matrimonial conflicts. And let us resume it because last time class, what is Dorcas? Can you unmute and read what I posted on the screen? It's a governing to the students of the advanced private international law. And here they say family matters, and the two pairs are there, wife and husband, having the one child, two childs, one female and one male. That is shown over there. Plus gavel, Gavel, gavel also be shown over here. Dorcas, are you hearing me? Say yes. So now let us, I could not hear your voice. I could not hear your voice, Dorcas.
Good evening, Prof.
Good evening. Now I could hear your voice because I started it and I'm asking it. I did not get the reply. That's why I started it also. And recording is also in progress. So in my last class, we are saying a marriage is formally valid when any one of the following conditions as to the form of celebration is complied with, within parentheses, that is to say, number one, if the marriage is celebrated in accordance with the form required or recognized as sufficient by the law of the country where the marriage was celebrated. That is the first condition. And if the marriage is celebrated at that instance where the law will allow it, and if the marriage, second condition is if the marriage was celebrated in accordance with the English common law in a country where the use of the local form is impossible. So these are the two conditions should be fulfilled over there to say the marriage is a valid marriage. And the next condition is if the marriage between the parties of whom at least one is a United Kingdom national is celebrated outside the Commonwealth in accordance with the provisions and the form required by the Foreign Marriage Act 189, 1892. So this is the conditions for it. Now I am asking you, what would be the valid conditions to marry in Tanzania? Unmute and give me the reply. Dorcas,
Yes, Prof.
I asked the question.
Yes.
I want the reply from
The conditions vary depending on the type of the marriage.
Okay, can you tell me at least one type of the marriage which are in Tanzania?
Okay. Okay. If it is a religious marriage, let's say it's a Christian marriage. First of all, a man should be 18 years or above. A woman should be not less than 15 years. And a man should only have one marriage, that is the marriage which he is about to contract. And a marriage should be between a man and a woman.
And it will not be there in the marriage would be conducted in the church? No church? Any place it
Yes,
can be conducted?
it should be conducted by a religious leader, not necessarily in a church, but a place where a religious leader will be there.
Okay, and then what are other conditions? Any signature is
And
needed?
before that, there should be a 21 days notice that the marriage should be announced.
If anybody is having an objection, they can raise the objection there.
Yes, Prof.
What about the father, mother consent?
It should be there, Prof.
Suppose if the father, mother will not give the consent, then what do you do?
You can still get married.
And there is no signature will be taken by the respective father and mother in the book or in the paper, on the paper.
It is not mandatory. Those who should sign are those who are witnesses of the marriage, not necessarily parents of the parties who are getting married.
The person, those who are signing as a witness, should be hailing from the same place, or he can hail from the Uganda or in India.
They should come from the same place.
Whether the woman should be there or the man should be there.
A man and a woman.
I mean the witnesses.
Yes, the witnesses should be a man and a woman.
How many should be there? How many witnesses? 1, 2,
Two.
3, 4.
Two, Prof. Two.
Yes. I will give the condition. If the Muslim marriage in India, if it is so, let us presume it. The witnesses, there should be two. Among the two, at least one should be the male, and the other either male or a female, doesn't matter. If female is there, the female 2 witnesses, male 1 witness. Female 2 witnesses, male 1 witness, then it becomes 2 witnesses. If I be not wrong. So a woman will be treated as a half witness, or the 2 will be count as a 1. So there is a number would be there, and that number should be, and moreover another condition also they make it out. They should be from the relative side, preferably. Anyway, that is a certain conditions are there, and I forgotten whether it is a 2 or 4 would be needed. If the 4 would be there, at least not 4 women. 4 women is equal to only 2 witnesses. Yeah, I got the condition. Just let me check it because how I could I forgotten even myself also wondering because I thought
You
just to
got
check.
married a while ago.
Pardon?
I'm saying you got married a while ago. Maybe that is why you forgot.
No, no, not like that. Not like that. Muslim law in India, no, no, needs how many witnesses? No, because I remember it is a 4 if it is a 2 witnesses. This free and mutual consent must be expressed in one and the same meeting in a clear ambiguous word. The presence of the 2 witnesses required for the parties are, and if yes, 2 witnesses. In the 2 witnesses, four female will not be considered. 4 female will not be considered. Only 2 will be considered as a 1, and 1 male should be there. So that is the only we can say that how many witnesses are required for the Muslim marriage. Yes. Under the Sunni law, proposal acceptance must be made in the presence of 2 male or 1 male and 2 female witnesses, and who are same, adult and Muslims. Under Shia law, witnesses are not necessary at the time of the marriage. They are required at the time of the dissolution of marriage. There is some difference would be there in the Shia law and Sunni law. So my doubt is cleared. Yes, it's the 2, but I know it the 2 women is equal to 1 man witnesses. So that was the condition should be there in the witnesses. They should be same and preferably from the same place, and then only that marriage would be a valid marriage. So the leading more modern authority in England on the point is Sotomayor, otherwise De Barros versus De Barros case law, where the Court of Appeal held that the law of the country where the marriage is solemnized must alone decide all questions relating to the ceremony by which the marriage is alleged to have been constituted. That is what is the Latin terminology? Equivalent Latin terminology with connecting factor. Yes?
Celebrationist.
Lex loci celebrationist. Where the marriage is conducted, there the formality should be fulfilled over there. But as in other contract, so in that marriage, personal capacity must depends on the law of the domicile. See, this is the very important point. Suppose, what is the personal capacity? Means whether a marriage is there or not, that depends upon the domicile of that person. That is a very important factor. For suppose a Tanzanian went to the England and he wants to marry there in England, and both the man and woman is from Tanzania. At that instance, the marriage will be conducted as per the norms of Salmonized, as per the norms of the England, but whether the two persons, that is a male and a female, having the capacity to marry, it depends on the law of the domicile. When you say the Tanzanian, the law of the domicile is the Tanzania. In the Tanzania, whether they will allow it to marry, the capacity would be marry or not, that will be counted. If it is not capacity to marry, at that instance, the marriage will not be solemnized in England. And if the laws of any country prohibits its subject within certain degree of the consanguinity from contracting marriage and stamp a marriage between the stopped, not stamp, and stamp a marriage between person with the prohibited degree as incestuous. Stamp no. And stopped marriage, not stamp. Stopped a marriage between the person within the prohibited degree as incestuous. A close relative marriage between the close relations is called incestuous. So it is called, what is the mean by consanguinity? Dorcas,
Yes, Prof.
what is understand by the consanguinity?
People from the same family.
Same relations, blood relations. Blood relations. That is meant by consanguinity. So let us see the another case law. Bartholomew versus Dastos. Bartholomew versus Dastos, a decision of the Privy Council in an appeal from Canada held that marriage would be regarded as a valid if the form adapted by the parties was in conformity with the law of the country where the marriage took place, even if it was not a proper form of law of the domicile of the parties. So what it actually says now, regarding the formalities are concerned, lex loci celebration is, and regarding the substantial law is concerned, it is yes. Give the answer.
Please repeat, Prof. I didn't get your question.
If the formality of the marriage is concerned or the procedure is concerned, it depends upon where the marriage is conducted. That means lex loci celebration is. But as the substantial law is concerned, it depends upon the
Law of domicile.
law of the domicile of the parties. Why you are taking so much time? It is on the screen also there. And moreover, as I told you also, procedure is concerned, formality is concerned, it will be the place where the marriage is solemnized. But as per the capacity is concerned, substantial law is concerned, it will depend upon the party's domicile. Is it clear?
It is clear, Prof.
Yes, very good. In English law, because Indian law or Tanzanian law is borrowed from the English law. In all aspects, general aspects are the same. But in certain aspects, the local customs and religious customs, religious practices will be practiced. So in English law, two rebuttable presumptions are drawn, presuming the validity of the marriage. Rebuttable means say no. Presumptions are drawn, presuming the validity of the marriage. A, that if the parties go through a ceremony of a marriage and live together, they were validly married. B, second one, if the parties cohabit and are reputed to be married, they are regarded as validly married. There must, however, be some evidence that the marriage complied with the local form. Either two ways, the marriage is valid. Like in Tanzania, civil marriage is there, religious marriage is there, and customary marriage is there. And three are valid as per the Law of Marriage Act, which is the year. Law of Marriage Act, which is the year.
1971. 1971, Prof.
1971, because last time we checked it. I would like to see whether you could remember it or not. Even I missed it because I taught long back, and hence it is difficult for me to know it. But I know the Hindu Marriage Act of 1955 because there I taught Hindu marriage as well as the Muslim marriage, Hindu law as well as the Muslim law, and that's why I could know the two countries' laws, India and Tanzania. So, position in the common law countries. Next is, how is the position in the common law countries? Number one, position in Australia. Marriage by proxy will be recognized as a valid if they are valid under
Prof,
the.
may you please
Yes.
repeat the two conditions above? May you please repeat the two conditions
Okay.
above, the rebuttable presumption?
Rebuttable presumption here is number one, that if the parties go through a ceremony of a marriage and live together, they were validly married. If the parties go through a ceremony of the marriage and live together, here ceremony of the marriage means whatever the conditions are there, formalities are there, that will be fulfilled, the place where the marriage took place. Number one. Number two, if the parties cohabit, means sleep together, that is the BBC, having the intercourse, and are reputed to be married, and everybody knows that they are married, they are regarded as a validly married. There must, however, be some evidence that the marriage complied with the local form. But a certain evidence should be there, they complied with the local form, the marriage. In these two conditions, if it is fully fulfilled over there, it is enough. That is comes under the rebuttable presumptions are drawn, presuming that the validity of marriage. For instance, nobody knows a wife and husband they married very long back. Are they married or no, not married? Nobody knows in the village. But they are living together as a wife and husband, and they are having the grandchildren also. They are having the Baba, what do you say?
Grandchildren.
Grandchildren, Baba, what do you say? Grandchildren.
Wajukuu.
Mujuku, is it for the male or female?
Both.
Both. So even the Mujuku also there. And nobody knows that whether they married or not. Presumption is
They are married.
validly they married, presumption, unless until somebody will challenge it. That is called rebuttable. The rebuttable that they are not valid marriage, if somebody challenges it, then only it can be there. Naturally, whenever a person marries now, they will take the photograph. Sir, at the time there is no photograph, sir. At least the people will be there for the celebration. Or suppose they run away from the home and they get married, at least the priest would be there. Either church or the masjid or any other religious place, at least that person would be there and who would be a witness. Of course, that person is no more over there. Actually, who will challenge it? You tell me. Tell me who will challenge it.
The person who is interested for a concubine or anybody else.
That is the point. If the children of concubine or the children of Machumba, if it is born over there, they may make some challenge just to get some money from the either the father or deceased father. So at that time only they will challenge it. Otherwise, nobody would challenge it. Even though he is having the one more than one wife also. And where the law will not allow it to have the one more one life. Suppose if somebody is having the two wives in Tanzania, you tell me, can anybody will challenge? Sir, how could he is having the two wives? Unless he is having interest in that second wife. And second wife is the farmer, Machumba of this fellow. At that instance, no, nobody will challenge it. Only the condition is, only the point is, somebody should have to tap the door of the court. Then only the dispute will arise. Otherwise, no one goes to the court, even no one bothers about it. But a government employee, if he could do so, naturally they will take an action. Because how could you have the two wives? Because law will permit only to have monogamy in Tanzania. I don't know whether the government will take the cognizance or they will consider it or not. I doubt also. But generally, if anybody challenges it, this fellow is having a government employee, and moreover that he is having the more than one wife, and that to be living in Tanzania, I don't know what the government will take on action against that person. Any idea, Dorcas? Any idea?
No idea.
No, even I don't think such a case will come out. Such a case will come out, I don't think, unless their children will go to the court. These, which children? Second wife children. Okay, then the dispute will come over there. At that instance, they will ask, in the law, you are said to be the illegitimate children. So illegitimate children are not going to get any inheritance. Can illegitimate children will going to get the inheritance in Tanzania? Yes. Answer. Answer my question. Dorcas, say pass on.
Prof, there is a network problem. Please repeat. No, please repeat the question, Prof.
Can illegitimate children entitled to inherit the property of his father?
Yes.
I don't think that it will be there. But as the equity principles are there, either the children are legitimate or illegitimate, they are entitled for the inheritance. Because there is no fault of the
Yes,
child.
Prof. And due to the law of the child, the law of the child protects even the illegitimate children, so they are entitled.
Because law says at the no fault of the child, why the child should be victimized? And they follow that principle, and they say even but mother will not get it. Child will get it, but mother will not get it. Child mother, because she is not validly married. That is there, as far my knowledge goes. Yes, it is there. But let us see once again the Law of Marriage Act, what it says. Is there any provision would be there which says that even a children, illegitimate children also can entitle for the inheritance? Because I taught very long back now, I could have no idea, but unless until I search it. But anyway, that I will also search, if it is so, that I will teach you tomorrow. Yes. So that is the position there in the Australia. And what they said is marriage by proxy. Okay, proxy marriages are allowed in Tanzania. Yes. Do you know what is meant by proxy marriage? Say yes or no. Do you know what is meant by proxy?
Yes. Yes.
Is it allowed in Tanzania? But in Muslim law, there,
Uh,
yes, please proceed.
yeah, I wanted to say that the Muslims do practice
Yeah, that's the only Muslim
proxy
law.
marriages.
If there is a flight cancelled is there and the marriage is fixed, any one of the family relative will sit and they will conduct the marriage. There it will be the such a situation, it will be allowed. But in practice, I did not see the proxy marriage. But in Australia, they say marriage with the proxy will be recognized as a valid if they are valid under the Lex Lucy celebration is where it is taken place. Okay. Next, second point is where the marriage is performed without the presence of an ordained priest, a specified priest. It has been held that the marriage would not be recognized in Australia. So it is a recognized priest would be there. Of course, the government will issue a license to them to solemnize the marriage. But I don't know what is the position in Tanzania, whether the government will give the license to them to solemnize the marriage is the question. Of course, the people accept he is a father, a parokia, and under him that every service is undertaken, and I think that he will be eligible to solemnize the marriage. But in specifically in India, it is there, they recognize it and they will give the license, something like that, and they can solemnize the marriage. So here ordained priest means a specifically recognized priest. Then only the marriage is a valid marriage in Australia. Let us see the third condition. Australian court also recognize as a valid marriage performed according to the religious ceremonies of the parties, good, like Tanzania, even if the formalities prescribed by the law of the place where the marriage took place were not complied with the condition prevailing in the time, at the time, whether the parties were British subject or not. Okay, they say formalities will never be necessary and a marriage would be conducted under the religious ceremony. And Tanzania also having a religious marriages, civil marriage, customary marriage. These three types of the marriage are recognized in Tanzania on the Law of Marriage Act of 1971 also. Okay, it make the validity. Let us see what is the position in Canada. The formality, the formal validity of the marriage is generally determined by the Lex Loci celebration is okay, that is a connecting factor. The lack of parental consent, when required by the lex domicili, is treated in the Canadian common law province as in England. That means consent of the parent is necessary in the both the places. Lex domicili, where the domicile is treated in the Canadian common law province as like in England, the parental consent is necessary as a question of formal validity and therefore gone by the law of the place where the marriage is celebrated. And in Tanzania, I think for the civil marriage, there is no question of a consent. But the religious marriage, generally, it will be by the consent of the parents, and the customary marriage also, it is with the consent of the parents and relatives. I am sure that it will be solemnized in that manner, or conducted in that manner. Am I right? Answer.
Yes.
Next, if the lex loci recognizes, means law of the place. Lex loci means no. Law of the place where the act is conducted. Yes, if the act is conducted means marriage is solemnized. Recognized as a valid a marriage by the cohabitation and repute, such marriage will be accepted as a valid marriage in Canada. And lex loci means where the it is conducted. If the lex loci, lex fori means where the forum. Lex loci, the place where they are hailing from, or the cause of action recognized as a valid Yes, here Lex Loci, we can say where they hail from. That would be the correct answer here, because Lex Fori means where the case is filed, means place. A valid marriage by cohabitation and repute, such marriage will be accepted as a valid marriage in Canada. In most of the places, statute says if they are living together as a wife and husband under the one roof, the presumption is that they are got married. But we don't say union, and union is not recognized, as far my knowledge goes, either in India or in Tanzania. What do you say? Answer. Did you hear my question?
No,
Did you hear my question? Anyway, there is no reply from you. Generally, the union cannot be
no,
recognized.
Prof.
Yes?
Please repeat the question.
Can the union will be recognized in Tanzania?
I don't think so, Prof.
Person.
To me, in writing, a union cannot be recognized as a wife and husband, but a presumption is there. They are living as a wife and a husband under one roof for a long time, and the Mujuke also there, the grandchildren are there. Presumption is that the marriage is a valid marriage, unless somebody challenges it. Is it clear?
Yes.
Yes. If a marriage through a invalid by the lex loci, means place from where they hail from, when considered, is retrospectively validated in the foreign country, like the marriage will recognize as a valid in Canada, even if by then both the parties were domiciled in Canada. See, two Tanzanians went to South Africa and they got married in gay marriages. That marriage is not valid at all, because the country will ask, what is their domicile? They say Tanzania. In Tanzania, such a marriage will be allowed. No, and we don't want to conduct the marriage. Okay, we'll solemnize your marriage, provided you change your domicile from Tanzania to South Africa. If once you will become a South African, yes, we follow the formalities, and your substantial law of capacity to marry is a South African law. So that is the third point where it can be made. If the marriage, though the invalid by the lex loci, means the place where they are hailed from, when considered, is retrospectively validated in the foreign country, the marriage will recognize as a valid in Canada, even if then both the parties were domiciled in Canada. So that is the condition they will put it over there. Do you know no man's land country is? In the world, there is one country, we say no man's land. Yes, tell me. Say, pass on.
Pass on.
The country is Canada. Canada, you could see all world people over there. It's no man's country. But do you know when you want to migrate to Canada, and they will give the points if you have the PhD, and they will give the migration free, and they will provide you the food, they provide you the employment till you will be self-sustained. And that is very much a good point. And intelligent people, their services will be taken over there. And all will be borne by the government. Because the people, those who are migrated, they say every school fees and everything the government will pay. So there is no problem at all of the social security over there. The people, those who migrated. But in certain like Vancouver and Quebec, and there is the countries minus degrees. Temperature is there. But anyway, that is called no man's land. Canada is a no man's land because you will find every nook corner of the world, you find it over there in Canada. So from India, many people are migrated to Canada. Even I got an offer, but my principle is wherever I born, I would like to die in that country. I born in India, I would die in India. That's my desire. I want to die in India. That is my desire. So that is called the no man's land, Canada. So now let us see the capacity to marry. Capacity to marry, it varies from country to country. But the international instruments, they made it at least a man should be 21 years and a woman should be 18 years for the marriage. But to my opinion, better both should be 24 years or at least difference of the 2 years or 1 year. So that is my thinking. And here let us see that essential validity covers all question of validity other than the formal validity. Formal validity means formality is different and substantial is different. Like parental consent is a formality in certain places. But in certain places, parent consent is a mandatory. Without that, there is no valid marriage. So here the capacity to marry is a category within essential validity. What is the capacity in Tanzania? Just now, Dorcas told. If the religious marriage would be there, at least the girl should be 15 years and the boy should be, 18 years. Boy in the sense, man. Capacity to marry ought strictly to be confined to rules which lay down that particular class of persons lacks a power to marry which other people possesses. For instance, rule a person below a certain age may not marry. Yes, definitely. International instruments say a man should be 21 years and the woman should be at least 18 years, means completion of 18 years. In practice, however, capacity to marry also includes cases where the reason for the invalidity. Suppose if doesn't have the capacity, is a minor, if you solemnize the marriage, yes, is the invalidity would be there. So is that such a marriage relationship is objectionable in the eye of law? Yes, it is in the eye of law, it is objectionable if anybody tap the door of the court. For instance, rules prohibited marriages between the relatives of certain degree. Yes, prohibited relationship should not be married. I don't know. Suppose if you marry in a particular family and the wife died, could you marry the wife sister? Yes. Answer.
Could you repeat the question, Prof?
Is it a difficulty for you to understand? In case a
No,
Tanzanian is
network.
married,
It's network.
a Tanzanian is married in another family and his wife died a natural death. Can such a person will marry the wife's sister?
No.
Yes.
Answer is yes. He can marry the wife's sister. Do you know what is the reason? Can you tell me what is the reason? Why the law will also allow? Suppose with the first wife he is having the children. if he could marry the another woman of a different community or different sect or the different far relatives, and that lady, when he got pregnant over there, where his children, her children would be there, and she will look after her children more than the children of the first wife. Suppose if you marry the wife's sister, at that instance, she is having the feeling that she is my sister's children, sister's children is my children, and hence the treatment is equal. Am I right?
You are right, Prof.
Because
You are right, Prof. But
even Muslim law, you will not allow it to marry wife's sister. Okay, wife died, you can marry. If the wife died, you can marry. But the Muslim law allows married the four. At that instance, you cannot marry the wife's sister. No. Either elder or younger, doesn't matter. But if wife died over there, then you can go for the wife's sister, you can marry. That the law will allow it. So that is the point. And when I was teaching the law of the child in the UDSM, I used to say this dialogue. Your children and my children are beating our children. I repeat, your children and my children are beating our children. Did you get my point? Did you
no.
get me? Huh?
Uh,
Dorcas,
there's a certain word I didn't get it. They are what? Our children?
our children and your children are beating our children. Oh, you are our.
Please
I don't get
explain.
the point.
Okay, now I'll tell you. See, my children, wife says to husband, wife says to husband, my children and you are your children are beating our children. Oh, you are our children. You did not catch me.
Um, if I may say this, what you mean is, you and your wife, your children that you have maybe with another woman are
Yes.
actually beating the children you're having, you and your wife.
See, the wife is having already children, and such a wife married to the another husband, and he is also having children, and both they married together, and they have their own children. So the wife says to the husband, my children means who are born to the another husband, and your children means your first wife, and for with her born your children, and we got married, and we got our issues, and that is called our children. So your children and my children are beating our children. Is it clear?
It is clear, Prof.
Yes,
Yes.
yes. That is my point. And I don't know whether do you have the law of the child here in South as a one of the paper? Yes. Do you have a course?
No,
Why you are
no,
taking that
no,
much
Prof.
time? Once I finish it, you have to say no, sir. And you see, I wrote a book with Clement Mashamba, The Law of the Child in East African community, East Africa. So we studied a lot in the law of the child, both the Kenyan law, Ugandan law, Tanzanian law, We made the comparative studies over there, and also we made the international instruments that is called CRC, and we followed that thing also. So the CRC is domesticated in Tanzania. So capacity to marry does not, however, cover the whole field of essential validity, and it does not include the consent of the parties or the non-consummation of marriage. Okay, where the consummation of marriage is consummation is must in Christianity. Otherwise, it will not be said to be a valid marriage. But in Islamic law, Muslim law, consummation, BBC, is must to be a valid marriage. Of course, before taking the, if you want to get the divorce before the consummation, at the time, I don't think that you are supposed to pay the inheritance. She is not entitled for the inheritance. Of course, certain rules are there. It depends upon the faith and religious life of a person. Christianity, a little difference would be there from the Hindu law, and a bit difference in the Islamic law. Yeah, Islamic law, they will follow the Shariat law, and they will follow it, and hence a little difference would be there. So consummation is a must in the Islamic, Muslim law. And here, non-consummation of marriage. In Hinduism, marriage is conducted today, and one day they will fix for consummation. I don't know, but that is the culture. I believe. I think they will fix for the consummation, and that day they are living together, and they will have the body-to-body contact. But in Christianity, I believe on the same day. Is it or not? What same days are? Before also, after also. Kama Qaida. Is it? Sir, we don't know, sir.
I believe so, sir.
Okay, it depends upon the attitude of a person and the community they belong and the faith they do have it. But in Tanzania, in India, it is very much clear. Kwanza Olewa, Pili BBC, Tatu Mimba, Inne Bototo. What is the sequence? Repeat. First, say.
First get married. Second, get pregnant.
BBC.
BBC, body to body contact.
How could that they get the pregnancy without the body to body contact? Kwanza, first marriage. Next,
marriage.
BBC,
body to body contact.
Next, Mimba.
And third
pregnant.
one,
next,
pregnant. Yes. Children.
It is the practice in India anywhere. Either you belongs to Christianity, or you belongs to Islam, or you belongs to Hinduism. Whatever the sequence here,